Welcome to the part 2 of the corporate litigations series. Here at the shareholder and partnership disputes, we have gone through the basics in the first part. What are the different types of shareholder and partnership disputes? Now we are in the part 2. Here we'll go with the 20 case laws of the Supreme Court and how those disputes have been resolved. Over to you, sir.
Yes, thank you. Friends, corporate litigation part 2 consists 20 leading Supreme Court judgments on corporate litigation, shareholder and partnership disputes in India. These landmark judgments of the Supreme Court of India have shaped the jurisprudence related to operation and mismanagement, minority shareholders' rights, share transfer disputes, partnership disputes, fiduciary duties, arbitration in corporate disputes, corporate governance, and director powers and shareholders' remedies. First case, Shanti Prasad Jain versus Kalinga Tubes Limited. Citation AIR 1965 SC 1535. Summary facts: minority shareholders alleged operation and mismanagement by majority shareholders in conduct of company affairs. Decision: the Supreme Court refuses relief and clarified the meaning of operation. Ratio decidendi: operation must be burdensome, harsh, wrongful, and continuous. Mere lack of confidence between shareholder is insufficient. Second case, Needle Industries India Limited versus Needle Industries New India Holding Limited. Citation 1981 3 SCC 333. Summary facts: foreign majority shareholders alleged oppressive conduct by Indian majority shareholders concerning share allotment and management. Very interesting case. The court granted equitable relief. Ratio decidendi: operation depends on fairness and probability. Courts may mold equitable remedies even where strict illegality is absent. 3. Sangram Singh P. Gaikwad versus Shanta Devi P. Gaikwad. Citation 2005 11 SCC 314. Summary facts: dispute arose in a family controlled company involving allegation of operation and diversion of company affairs. Decision: court examined scope of section 397 and 398 of Companies Act 1956. Ratio decidendi: operation must be evolved lack of probability. Relief is discretionary and equitable, and company interest is paramount. It is very most important case. 4. V.B. Rangraj versus V.B. Gopal Krishnan. Citation 1992 1 SCC 160. Summary facts: shareholders impose restriction on transfer of shares through private agreement. Decision: court invalidated restriction. Ratio decidendi: restriction on share transfer must be incorporated in articles of association. Private agreements alone are insufficient. Fifth case, MSDC Radha Ramanan versus MSD Chandra Sekhara Raja. Citation 2008 6 SCC 750. Summary facts: deadlock between director and shareholders paralyzed management. Decision: court upheld order directing share purchase. Ratio decidendi: company law board NCLT possesses broad equitable powers. Buyout orders may be passed even without strict proof of operation. 6. Tata Consultancy Services Limited versus Cyrus Investment Private Limited. Citation 2021 9 SCC 449. Summary facts. Cyrus Mistry challenged removal of executive chairman of Tata Sons, alleging operation and mismanagement. Decision: Supreme Court upheld Tata Sons action. Ratio dissenting: mere removal from directorship is not operation. Commercial wisdom of board deserves judicial restraint, and loss of confidence can justify removal. बहुत अच्छी केस है, ये पढ़ लेना जरूर. टाटा कंसल्टेंसी वर्सेस साइरस इन्वेस्टमेंट, बड़ी केस है, बड़ा केस लॉज है, लेकिन इससे काफी 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 सेक्शन, काफी आर्गुमेंट, काफी सबमिशंस कवर भी होते हैं, काफी केस लॉज कवर होते हैं इसमें, और कोर्ट का भी बहुत डिसीजन इसमें कवर होता है. मैंने पीछे भी लिया है, एंड ऑलरेडी इन माय बुक ऑन कंपनी लॉ लीडिंग केसेस का जो बुक मेरा है, मोर देन 65 प्लस बुक्स आई हैव पब्लिश्ड ऑन सुप्रीम कोर्ट केस लॉज, उसमें कंपनी लॉ के भी केसेस के बुक है, उसमें मैंने केस लिया हुआ है. 7 डेल एंड कैरिंगटन इन्वेस्टमेंट प्राइवेट लिमिटेड वर्सेस पीके प्रथपन. Citation 2005 1 SCC 212. Summary facts. Managing directors allotted shares to himself to gain majority control. Decision: court set aside allotment. Ratio dissenting: directors owe fiduciary duties. Shares cannot be issued for collateral purposes. 8. Sri Ramdas Motor Transport Limited versus Adi Narayan Reddy. Citation 1997 to SCC 334. Summary facts. Minority shareholders alleged exclusion from management. Decision: court recognized quasi-partnership principles. Ratio dissenting: in family companies, equitable considerations apply. Mutual trust is essential in closely held companies. 9. J.P. Srivastava and Sons Private Limited versus Gwalior Sugar Company Limited. Citation 2005 1 SCC 172. Summary facts. Dispute regarding operation and eligibility requirement for petition. Decision: court interpreted maintainability provisions. Ratio dissenting: technical objection should not defeat substantial justice. Courts must focus on real prejudice. 10. Kilpest Private Limited versus Shekhar Mehra. Citation 1996 10 SCC 696. Summary facts. Directors out winding up on just and equitable grounds. Decision: court declined winding up. Ratio dissenting: corporate personality cannot be lightly disregarded. Quasi-partnership doctrine applies only in exceptional cases. 11. Hind Overseas Private Limited versus Raghunath Prasad Junjunwala. Citation 1976 3 SSC 259. Summary facts. Petition for winding up due to management dispute. Decision: court refused winding up. Ratio dissenting: winding up is last resort. Court should prefer alternative remedies. Very good decision. दोस्तों, those who are hearing first time corporate case laws, so that there may be chances, so they cannot understand at first glance, but when they are repeatedly hear it again and again and again, then they will definitely get the interest in this case laws. और बहुत अच्छे वो कॉर्पोरेट फैकल्टी इसमें प्रैक्टिस भी कर सकता है. एक खाली कॉर्पोरेट में दिखते समय थोड़ा सा एट्रैक्टिव दिखता है फील्ड कि कंपनी है, बड़े बड़े कंपनी के मैटर आते हैं, लेकिन जितने होशियार लोग रहते हैं ना, उससे वो पैसा निकालना भी बहुत मुश्किल होता है. इसलिए जितने वो होशियार लोग हैं, उससे ज्यादा होशियार आप चाहिए. उनको जब लगता है ना ये वकील सही में बहुत होशियार है, तो फिर वो पैसे देंगे आपको, वो कोई इशू नहीं है. 12. Worldwide Agency Private Limited versus Margaret T. Desor. Citation 1991 SEC 536. Summary facts: legal hair sought continuation of operation proceedings. Decision: court allowed continuation. Ratio descendi: right under operation provision survive to legal representatives. 13. Mohanlal Ganpatram versus Sri Sayaji Jubilee Cotton and Jute Mills Company Limited. Citation AIR 1965 SC 772. Summary facts: dispute involved director misconduct and fiduciary obligations. Decision: court emphasized director accountability. Ratio descendi: directors occupy fiduciary position. Director must act bona fide for company benefits. 14. Life Insurance Corporation of India versus Escort Limited. Citation 1986 1 SCC 264. Summary facts: dispute concerning shareholder right and government interference. Decision: court protects corporate autonomy. Ratio descendi: shareholders exercise rights through resolutions. Judicial review in commercial matter is limited. 15. Bacha F. Guzdar versus Commissioner of Income Tax. Citation AIR 1955 SC 74. Summary facts: issue concerning shareholder operation rights. Decision: court clarifies legal nature of shares. Ratio descendi: shareholder does not own company's assets. Company has a separate legal personality. 16. Vodafone International Holding BV versus Union of India. Citation 2012 6 SCC 613. Summary facts: major international corporate acquisition involving indirect transfer of Indian assets. Decision: court ruled in favor of Vodafone. Ratio descendi: corporate structure must be respected unless sham. Commercial substance important in corporate transaction. 17. Keloro Control India Private Limited versus Severn Trent Water Purification Industry. Citation 2013 1 SAC 641. Summary facts: issue involved arbitration in complex shareholder and joint venture agreements. Decision: court explained scope of arbitration. Ratio descendi: non-signatory may be bound by arbitration agreement in composite transactions. Case number 18. Booz Allen and Hamilton Industries versus SEBI Home Finance Limited. Citation 2011 5 SCC 532. Summary facts: court examined arbitrability of disputes. Decision: certain dispute held non-arbitrable. Ratio descendi: right in rem are generally non-arbitrable. Operation and mismanagement claim largely remain within tribunal jurisdiction. 19. V.S. Krishnan versus Westport High Tech Hospital Limited. Citation 2008 3 SSC 263. Summary facts: allegation of illegal board meetings and operation. Decision: court discussed maintainability and remedies. Ratio descendis: company NCLT Company Law Board has wide power to grant equitable relief. 20. Ibrahimi versus Westbourne Galleries Limited. Citation 1973 AC 360. Summary facts: partnership style company dispute involving exclusion from management. Decision: company orders to be wound up. Ratio descendi: quasi partnership principles applies is closely held companies. Equitable consideration overriding strict legal rights. Though foreign extensively relied upon the Indian Supreme Court in shareholder operation jurisprudence. Now I am giving you one summary chart कि भाई कौन से प्रिंसिपल के ऊपर कौन सा लीडिंग केस है, कौन से प्रिंसिपल के ऊपर कौन सा लीडिंग केस है, इसका एक कंपैरेटिव चार्ट मैं बता रहा हूं आपको. बिफोर दैट एज यूजुअल हम ये प्रोग्राम होने के बाद आपके चार्ट पढ़ने वाले हैं, एंड इन दैट चार्ट वॉट एवर यू हैव रिटन आई विल रीड दैट विथ योर नेम. ओके, अब किसी ने थैंक्स बोला है, किसी ने कुछ क्वेश्चन पूछा है, आई विल गिव दैट आंसर. किसी का कुछ क्वेरी है, आई विल एक्सप्लेन दैट. किसी को अप्रिसिएशन करना है, यस आई विल रीड विथ हिज नेम. किसी को कुछ सुझाव देना है, सजेशन देना है, यस वी विल एक्सेप्ट दैट. क्योंकि आपके सजेशन से ही ये प्रोग्राम दिन पे दिन और आपको नया नॉलेज देते रहेगा, ये याद रखना. प्रिंसिपल और लीडिंग केस. मीनिंग ऑफ ऑपरेशन शांति प्रसाद जैन केस. इक्विटेबल रिलीफ इन कॉर्पोरेट डिस्प्यूट नीडल इंडस्ट्रीज. fiduciary duties of director Dale and Carrington. Share transfer restriction VB Rangaraj case. Quasi partnership doctrine Sri Ramdas Motor case. Board commercial wisdom Tata Sun versus Cyrus Mistry. Winding up as a last resort Hind Overseas. Arbitration in shareholder dispute Chloro controls. Rights in rem not non-arbitrable Booz Allen case, and separate corporate paternity Bacha F. Gulzar case. Now conclusion. The Supreme Court of India has developed extensive jurisprudence governing shareholder dispute, partnership conflicts, operation and mismanagement, fiduciary duties, arbitration and corporate governance. These judgments collectively establish protection of minority shareholders, accountability of directors, sanctity of corporate responsibility, equitable remedies in closely held companies, and judicial balance between commercial freedom and shareholder protection. Modern corporate litigation in India continues to evolve through NCLT and NCLAT jurisprudence, arbitration mechanism, and Supreme Court oversights, making these landmark cases foundational precedent for corporate and commercial litigation practice. So friends, today we have taken more than 1 hour, but we have completed 2 parts. On YouTube channel, you will see the separate part separately. So first part will be a separate video, second part will be separate video. Blog भी आपका फर्स्ट पार्ट का अलग होगा पब्लिश, और कुछ दिन के बाद फिर पार्ट सेकंड होगा, और कोर्स पे जाते समय ये सब इकट्ठा आ जाएगा, दोनों पार्ट का मिलके एक कोर्स बनेगा ऐसा. हाँ. So now yes, I want to read the chart. ठीक है, चार्ट में तो कुछ दिखना नहीं है. ओके, नाउ Manoj, I'm unmuting you. You can unmute yourself and conclude this session.
Thank you very much, sir. Thank you, participants. I request the participants that first you go through the part 1 and then you come to the part 2 to understand in a better way. Because part 2 is a continuation of part 1 where you will get the basic ideas about the shareholder and partnership disputes, and for those disputes you will get the 20 case laws in a part 2. Thank you very much, sir. Thank you, participants. Thank you.
Thank you.